Hello students, the topic for the day is Special Status to Women under Indian Constitution, a Study. Introduction of the topic. The Indian Constitution is a living document that embodies the aspirations of its people for social justice and equality. It lays down a framework that mandates not only equality before law but also the provision of equal status to certain groups to address historical injustice and inequalities. Women, constituting nearly half of the India's population, are one such group that the Constitution recognizes as deserving special attention to rectify gender disparities. The status of a woman in India has been a subject of significant evolution and change. Historically, during the early Vedic period, women enjoyed equal status and rights. However, their status began to decline around 500 BC with the advent of texts like Manusmritis, which imposed restriction and defined gender roles more rigidly. The medieval period says further curtailment of women's rights and freedoms. With the Islamic invasions and later the British colonial rule, which brought its own set of laws and societal norms. The post independence era marked a turning point with the drafting of the Indian Constitution, which enshrined principles of gender equality and non discrimination. Landmark legislation such as Hindu Succession Act of 1956 and Dowry Prohibition Act of 1961 aimed to address discriminatory practice and provide legal protection to women. The Constitution of India, adopted in 1950, laid down the foundation for a new era where women were granted the same rights and opportunities as men. The Constitution, through various articles, specifically addresses the state's role in ensuring that women are not only protected from discrimination but also empowered through affirmative action. For instance, Article 15, Clause 3 allows the state to make special provisions for women, recognizing the need to take positive steps to improve women's participation in all spheres of life. Constitutional provisions. The Constitution of India provides several provisions that grant special status to women, aiming to promote equality and counteract historical discrimination. Article 14, Equality before law. This article guarantees equality before law and equal protection of law to everyone within the territory of India. It forms the cornerstone of the right to equality in India and applies to both men and women. Article 15, Clause 1, Prohibition of discrimination. It prohibits the state from discriminating against any citizen on ground only of religion, race, caste, sex, place of birth, or any of them. This ensures that women have the same rights as men in political, economic, and social spheres. Article 15, Clause 3, Special provision for women. This clause allows the state to make special provisions for women and children. It enables the state to create affirmative action policies in favor of women, recognizing the need for positive discrimination to uplift women's status in society. Article 16, Equality of opportunity in public employment. This article ensures equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state, thereby including women in its ambit. Article 23, Prohibition of traffic in human beings and forced labor. This article bans trafficking in human being and forced labor, providing protection of women against such practices. Article 39A and D, Economic Rights. These clauses direct the state to ensure that all citizens, men and women, equally have the right to an adequate means of livelihood and equal pay for equal work. Article 42, Provisions for just and humane conditions of work and maternity relief. The state is directed to make provisions for securing just and humane condition of work and for the maternity relief which is crucial for the working women. Article 51A, subclause E, renunciation of practices derogatory to the dignity of women. This part of the fundamental duties call upon every citizen to renounce practices that are derogatory to the dignity of the women. Article 300 capital A, right to property. This article provides the right to property, which includes the right of women to own and manage property. 73rd and 74th Amendment Act of 1992, political empowerment. These amendments reserves one-third of the seats in local bodies of panchayats and municipalities for women, promoting their political representation and participation. These provisions collectively work towards creating an environment where women can exercise their rights and freedoms on an equal footing with men. They are a reflection of the constitutional commitment to building a society based on gender equality and justice. Now, what are the affirmative action? Affirmative action in context of the Indian Constitution refers to the policies and measures taken by the state to promote the welfare of the women and to bring about gender equality. Affirmative action for women in India is rooted in the constitutional mandate to ensure gender equality and empower women through positive discrimination. This is primarily reflected in Article 15, Clause 3 of the Constitution, which allows the state to make special provisions for women. Such provisions are aimed at leveling the playing field and rectifying historical injustices faced by the women. Judicial precedents. Several landmark judgments have shaped the discourse on affirmative action for women in India. The most important case is Vishakha and other versus State of Rajasthan 1997 Supreme Court cases page number 241. This case led to the formulation of the Vishakha guidelines which laid down the procedures to be followed in cases of sexual harassment at the workplace. It was a significant step in creating a safe and conducive work environment for a women. Government of AP versus PB Vijay Kumar, cases of 1995, page number 520, the Supreme Court held that providing reservations for women in public employment is constitutionally valid and does not violate the general principle of equality. The next important case is McNin Mackenzie Company Limited versus Audrey D. Costa. This case is of 1987 and it is cited at page number 469. The court upheld the principle of equal pay for equal work for women, reinforcing Article 39, Clause G of the Constitution. Now, coming to the women's representation. The need for affirmative action is underscored by statistics that highlight the underrepresentation of women in various sectors. Political representation. As of recent data, women hold only 14.94% of seats in the Lok Sabha and 14.05% in Rajya Sabha, indicating a significant gender gap in political representation. Education and employment. In field of higher education, particularly in the sciences, women constitute nearly 50% of the student enrollment, but only 25% of the faculty positions, suggesting a disparity in academic employment opportunities. Quotas in government. The affirmative action program in India include quota of 22.5% in government educational institution, government jobs and all levels of elected bodies for scheduled caste and scheduled tribes which also benefit women from those communities. Equality in employment. Equality in employment for women is a fundamental right and a crucial aspect of gender equality. Despite significant progress, women in India still face challenges in achieving parity in the workplace. The Indian Constitution, through Article 16, ensures equality of opportunity in matter of public employment, prohibiting discrimination on the basis of gender. However, the reality on the ground reflects a different picture with women's workforce participation standing at under 28%. The gender gap in employment persists due to various socio-economic barriers, including unequal pay, limited career advancement opportunities, and the disproportionate burden of unpaid care work. Addressing these issues require not only legal provisions but also societal change, supportive policies, and inclusive practices to create a level playing field for the women in the labor market. In case of Randhir Singh versus Union of India, 1982 Supreme Court, page number 298. This case is significant precedent for the principle of equal pay for equal work. The Supreme Court held that although equal pay for equal work is not expressly declared by the Constitution as a fundamental right, it is certainly a constitutional goal and is derivable from Article 14, 16, and 39C of the Constitution. The most important case of National Legal Service Authority versus Union of India of year 2014. In this landmark judgment, the Supreme Court recognized the right of transgender persons, including their right to decide their self-identified gender, and affirmed the provisions for reservation in jobs and education under Article 15 and 16 of the Constitution. This case is a significant for gender equality in employment. Coming to the economic and property rights. The Constitution of India enshrines the economic and property rights of women, reflecting the nation's commitment to ensuring gender equality and empowerment. Article 14 guarantees equality before law and equal protection of laws to all citizens, laying the foundation for non discrimination on the basis of gender. Article 15 Clause 1 prohibits discrimination against any citizen on the ground of religion, race, caste, sex, or place of birth, while Article 15 Clause 3 empowers the state to make special provisions for women, thereby supporting affirmative action. Article 16 ensures equality of opportunity in matter of public employment, reinforcing the right to work without gender bias. Economic rights are further supported by Article 39A, which directs the state to secure an adequate means of livelihood for all citizens, and Article 39D, which mandates equal pay for equal work for both men and women. Additionally, Article 42 obligates the state to make provisions for just and humane condition of work and maternity relief, crucial for the economic security of working women. Property rights are also protected under the Constitution with Article 300A providing the right to property, which includes women's right to own and manage the property. This constitutional framework is complemented by personal laws such as the Hindu law, which through the Hindu Succession Act of 1956 as amended in 2005 grants the daughter the same right as the son to their ancestral property. The Supreme Court of India has been instrumental in upholding these rights through the landmark judgments. In case of Air India versus Nargesh Mirza of year 1981, the Supreme Court struck down the regulation that required an air hostess to retire upon first pregnancy as unconstitutional. In case of Vinita Sharma versus Rakesh Sharma, this is of 2020 case, the Supreme Court ruled that daughters would have equal co-partnership rights in Hindu undivided family property, ensuring economic rights related to inheritance. Together, these constitutional articles and judicial interpretations form a robust legal framework that supports the economic and property rights of women, ensuring their full participation in country's economic and social life. This synergy between economic rights and property rights is crucial for achieving true gender equality and empowering women to be independent and self reliant individuals in society. These cases reflect the evolving jurisprudence on women's right to equality in employment and economic rights in India, providing a legal framework that supports the constitutional mandate for gender equality. Now, coming to health and maternity relief. Health and maternity relief for women in India are critical aspects of gender equality and are enshrined in the Constitution as well as upheld by various Supreme Court rulings. Article 42 of the Indian Constitution directs the state to make provisions for securing just and human conditions of work and for maternity relief. This directive principle underscores the commitment to ensuring that women's health is not compromised due to the work conditions and they are provided adequate support during the maternity benefit. The Maternity Benefit Act of 1961. The Act is a legislative enactment following the constitutional directive which provides comprehensive maternity benefit to women employees. It includes provision for paid leave, medical bonus, and nursing breaks supporting women during childbirth and postnatal care. The Supreme Court of India has consistently interpreted these constitutional and statutory provisions to affirm the rights of women to health and maternity benefit. The leading case is Municipal Corporation of Delhi versus Female Worker Muster Roll and another. This is a case of 2000 decided by Supreme Court of India. The Supreme Court held that the right to maternity leave is not only a statutory right but it is a fundamental right under Article 21 of the Constitution which guarantees the right to life. The most recent case is Dr. Kavita Yadav versus the Secretary, Ministry of Health and Family Welfare Department and others. This is case of year 2023 and it is decided by Supreme Court. The court held that women engaged as fixed term employees are entitled to full maternity benefit under the Maternity Benefit Act even if the period of such benefit exceeds the term of their employment contract. The next important case is Shalini Dharmani versus State of Himachal Pradesh and this is case of year 2024 decided by Supreme Court. In a landmark ruling, the Supreme Court declared that 2-year childcare leave alongside mandatory maternity leave is a constitutional right for a women employees that cannot be denied. These judgments highlight the progressive interpretation of the law by the Supreme Court to protect and enhance the health and maternity rights of the women in India, ensuring that they can participate in workforce without having to compromise on their well-being and maternal responsibilities. Next, coming to the right against exploitation. Article 23 of the Indian Constitution serves as a vital legal safeguard, providing protection against trafficking in human being and forced labor. It explicitly prohibits any form of human trafficking and begar, forced labor without payment, and declares such practices punishable by law. This article is a testament to India's commitment to upholding the dignity and freedom of individuals, particularly women who have historically been more vulnerable to such exploitative practices. To bolster the provision of Article 23, India has enacted several laws aimed at combating trafficking and forced labor. The Immoral Traffic Prevention Act of 1956 targets trafficking for commercial sexual exploitation and prescribes stringent penalties for the offenders. The Bonded Labor System Abolition Act 1976 abolishes the bonded labor, a system where labor is demanded as a mean of repayment for a loan and criminalizes the perpetuation of such labor. The Child Labor Prohibition and Regulation Act 1986 prohibits the employment of children in certain hazardous occupation and regulates the condition of work of children in other occupation. The Juvenile Justice Care and Protection of Children Act 2000 provides for the care, protection, development, treatment, and rehabilitation of children in conflict with law or the children in need of care and protection. These laws are designed to protect the most vulnerable section of society, including the women and children, from being exploited through trafficking and forced labor. They also empower the judiciary and law enforcement agencies to take stringent action against those who engage in or facilitate such illegal activities. The Supreme Court of India has also played a crucial role in interpreting Article 23 to extend its protective cover. In cases like Sanjit Roy versus State of Rajasthan, AIR 1983, Supreme Court page number 328, the court held that payment of wages lower than a minimum wage to a person engaged in famine relief work is against the provision of Article 23, as the state cannot take advantage of the person's situation. Similarly, in case of Dina versus Union of India, this is case of 1983, it was held that labor taken from prisoners without paying them proper remuneration is against the provision of Article 23. In light of special status accorded to the women under the Indian Constitution, these legal safeguards play a crucial role in ensuring that women's rights to freedom, dignity, and fair labor practices are protected. The constitutional and legislative framework together create a robust mechanism to prevent and address the issues of trafficking and forced labor, contributing to the empowerment and upliftment of women in India. Now, coming to the judicial activism. The judiciary in India has been instrumental in interpreting and expanding the constitutional rights of women, ensuring that the spirit of equality and justice enshrined in the Constitution is realized in practice. Through various landmark judgments, the Supreme Court has addressed the issues of discrimination, violence, and inequality, thereby shaping the contours of women's rights in India. Landmark judgments and their impact. Now we have a leading case of C.B. Muthamma versus Union of India. This case is of 1979. In this case, C.B. Muthamma, the first women Indian Foreign Service officer, challenged the discriminatory rules that restricted women officers from serving in certain posts and imposed conditions on their eligibility for promotion. The Supreme Court acknowledged the gender based discrimination and held that rules violated the constitutional principles of equality, emphasizing that gender cannot be valid criteria for different treatment. The next important case is Vishakha and other versus State of Rajasthan. This case led to the formulation of Vishakha guidelines, which laid down the procedures to be followed in case of sexual harassment at the workplace. It was a significant step in creating a safe and conducive work environment for women. The next important case is Shaira Bano versus Union of India of year 2017. The Supreme Court in this case declared that the practice of instant triple talaq, that is talaq-e biddat, is unconstitutional. It was a landmark judgment that protected the right of Muslim women and upheld their right to equality under the law. The next important case is Mary Roy versus State of Kerala, the cases of year 1986. In this case, the Mary Roy's victory ensured equal inheritance right for Syrian Christian women in Kerala, which was a significant step towards gender equality in inheritance laws. The Supreme Court's decision was based on the constitutional mandate of equality. These cases, among others, have significantly influenced the legal landscape in favor of women's rights. The judiciary has not only provided redressal to individual grievances but also set precedent that have a far-reaching impact on societal norms and practices. Expanding constitutional rights. The judiciary has expanded the constitutional rights of the women by interpreting the constitution progressively. The courts have adopted a progressive interpretation of constitution, particularly the fundamental rights, to include a broad range of women issues. Upholding the personal autonomy. The judiciary has upheld the personal autonomy of women, including the right to make choice regarding marriage, reproduction, and employment. Ensuring workplace equality. courts have been instrumental in ensuring workplace equality, striking down discriminatory practices, and upholding the right to equal pay for equal work. Protecting against violence. The judiciary has taken a strong stance against violence and harassment of women, setting guidelines for preventing and redressal. Promoting political participation. The courts have also supported women's political participation, interpreting the constitutional provisions to encourage affirmative actions and representation. According to the National Family Health Survey, the percentage of women who have experienced physical or sexual violence has seen a decline, indicating the impact of legal provisions and awareness. Moreover, the literacy rate among women has been steadily increasing, reflecting the constitutional commitments to providing equal opportunities for education to women. Now, I'll be discussing with you the global perspective on women's rights. The quest for gender equality has led nations worldwide to adopt various constitutional and legal measures. This comparative study examines how different countries have embedded special provisions for women within their legal frameworks, reflecting the global tapestry of gender rights. First is the United States. In United States, the Constitution does not explicitly provide for women's rights. However, Equal Protection Clause of the 14th Amendment and federal laws like the Violence Against Women Act and Title IX plays a pivotal role in safeguarding the gender's equality. The United Kingdom, the UK's uncodified constitution means that women's rights are protected through acts like the Equality Act of 2010, which serve as a cornerstone for gender equality and non-discrimination. The next country is Australia. Australia's constitution is silent on women's rights, but the Sex Discrimination Act of 1984 and subsequent legislation provide robust protection against gender discrimination. Coming to Canada, Canada's Charter of Rights and Freedoms explicitly guarantees gender equality, ensuring that all rights are equally applicable to both men and women. The next country is China. China has taken legislative steps to protect women's rights with the Women's Rights and Interest Protection Laws and emphasizing gender equality and prohibition against discrimination. South Africa. South Africa's progressive constitution is renowned for its human rights stances, including specific provisions that advocate for women's rights and promotes gender equality. Coming to Pakistan, Pakistan's constitution guarantees fundamental rights to all citizens with the articles allowing the state to make special provisions for the protection of women and children. India. India's constitution enshrines gender equality as a fundamental right with provisions like Article 15 Clause 3 and the 73rd Amendment which empowers women politically by reserving seats in local government bodies. Now I'll be discussing with you other Asian countries. Japan and Nepal represent Asia's diverse approach to women's rights, with Japan focusing on employment equality and Nepal embedding proportional inclusion principles in its constitution. Middle Eastern countries. Middle Eastern nations such as UAE and Saudi Arabia have recently initiated reforms to enhance women's rights, though these are not always constitutionally enshrined. Latin American countries. Countries of Latin America, like Brazil, have constitutional provisions and special laws that promote gender equality and protect the women's rights. African countries. Beyond South Africa, Rwanda has made notable progress in women's parliamentary representation supported by constitutional and electoral laws. Coming to the European countries, Sweden and Norway, known for their progressive policies, ensure gender equality through laws and practices rather than explicit constitutional provisions. This comparative analysis reveals a spectrum of approaches to women's constitutional rights, from explicit provisions to legislative measures and policy initiatives. The effectiveness of these provisions is often contingent upon each country's commitment to reinforcing these rights and the broader socio-political context in which they operate. This study underscores the importance of global dialogue and cooperation in pursuit of gender equality. Now, coming to the challenges which are faced. The implementation of legislative provisions often encounter a range of challenges that can hinder their effectiveness. These challenges can be broadly categorized into structural, procedural, and cultural factors. Now, coming to the structural challenges, these involves the inherent complexities with the legal and administrative system. For instance, provisions of the Panchayat Extension to Scheduled Areas Act 1996 was enacted to empower local governance in scheduled areas. However, the Act's implementation has faced obstacles due to the lack of clarity in its provision, conflict with existing laws, and the absence of a supportive administrative framework. Now, coming to the procedural challenges. Procedural challenges arise during the operationalization of provisions. For example, the Right to Education Act, that is RTE, in India aims to provide free and compulsory education to children. Yet, its implementation has been marred by inadequate infrastructure, insufficient training of educators, and lack of awareness among the stakeholders. Coming to the cultural challenges, these are perhaps the most nuanced involved the socio-cultural dynamics of the targeted population. Provisions that require a change in traditional practices or beliefs face resistance, which can slow down or even nullify the intended impact of legislation. Now, coming to the critics. Critics often point out that top-down approach in implementing provisions fail to consider the local context and needs. There is also criticism regarding the pace of implementation, which is often slow, leading to a gap between the enactment of law and their actual impact on the ground. To overcome these challenges, a multifaceted approach is necessary. This includes reforming the legal framework to remove ambiguities, enhancing administrative capacities, and fostering community engagement to ensure that provisions are culturally sensitive and effectively implemented. In conclusion, while the enactment of provision is a step towards social reform, their success largely depends on addressing the multifarious challenges they face during the implementation. A critical examination of these challenges is essential for devising strategies that can lead to meaningful and sustainable changes. Now, I'll be discussing with you the future prospects. The future prospects for enhancing women's status under the Constitution are promising, particularly with the introduction of Women Reservation Act of 2023. This landmark act represents a significant stride towards empowerment and inclusivity in Indian democracy. Key feature of the Women Reservation Act of 23: one-third reservation. The Constitution 106th Amendment Act of 2023 reserves one-third of all seats for women in the Lok Sabha, state legislative assemblies, and legislative assemblies of the National Capital Territory of Delhi. Inclusion of SCs and STs. The reservation includes seats for scheduled castes and scheduled tribes, ensuring representation from these communities. Duration and extension. The reservation is set for a 15-year period with the possibility of extension through parliamentary action. Rotation of seats. The rotation of seats allocated for women will be determined by parliamentary legislation after each delimation process. Impact and significance. Increased representation. The Act aims to increase the representation of women in decision making bodies, which has historically been low. For instance, women constituted only about 15% of the 17th Lok Sabha. Compliance with International Convention. The Act aligns with the Convention on Elimination of All Form of Discrimination Against Women 1979, which India is a signatory to. Addressing intersectional challenges. The Act also acknowledges the intersectional challenges faced by women due to gender, class, and caste, compounded by the pervasive influence of patriarchy. Empowerment beyond symbolism. While the Act is a significant legal step, it is crucial to ensure that it translates into genuine empowerment and not just a symbolic gesture. Now, coming to the challenges and consideration. First is triple test compliance. The implementation of the Act will require adherence to the triple test laid down by the Supreme Court. Representation of other backward classes. Consideration of reservation for women from other backward classes at an appropriate time is recommended. Next is beyond elite leadership, ensuring that the Act benefits the women across various social strata beyond just elite female leadership is essential for true political participation. What is the real solution? The real solution lies in understanding the truth of the world. As Ramana Maharishi said, "Who am I?" For if one sees the truth, that individual goes beyond the barrier of the body or mind and hence becomes one with the ultimate. Women and men are absolutely equal in terms of universal existence. Consciousness, bliss, and nothingness. Buddha is one who has lost all that is illusory. The ultimate solution lies in not just acknowledging the bodily difference and working to provide appropriate environmental conditions for women, but more so important is the need of the arts to provide one with the self knowledge which is beyond all barriers. Jiddu Krishnamurti, Swami Vivekanand, Sarda Devi are some of the great luminaries who realized the truth, the ultimate, and spread the masses of the world and beyond. Swami Vivekanand vehemently supported for women's rights and he said that the best thermometer to the progress of the nation is its treatment to its women. Further, he said that is there any sex distinction in self, that is Atma, out with the differentiation between man and the women. All is Atma. Give up the identification with the body and stand up. Thus, women indeed needs to be given the understanding to give importance to work, consciousness, and truth that is beyond their bodies. More than body identified world, the need of the hour is the consciousness centric world, a world where there is a real love. As Jiddu Krishnamurti said that only the free mind can know what love is. Then we will not only be able to advocate for human rights but also of the rights of the animals and nature. Biocracy is the need of the hour and not just the democracy. Now I am concluding my topic. In conclusion, I would like to say in the pursuit of gender equality, the sense of providing special status to women under the Indian Constitution transcends the mere text of legal provision. It represents a broader commitment to rectify historical imbalances and pave the way for societal where women can thrive as equals. The true measures of this commitment is reflected not in the statute but in the everyday lives of women who experience enhanced dignity, opportunity, and empowerment. As India continues to evolve, the spirit of its constitution serves as a guiding light towards an inclusive future where gender parity is not just an ideal but a lived reality. That's all for today's lecture. See you in the next lecture. Till then, thank you and goodbye.